issue with your issue isn't with him saying he doesn't understand. He didn't understand at the time the requirements is the issue. Or is that
So the allegation is that he failed to enroll in alcohol and drug test and was ordered on the 7th of, or the 1st of July and the 2nd of July. He's saying he didn't know he was supposed to contact them, and it clearly says that he was supposed to.
but I think he means that he didn't understand the process, and I respect that. But you know, when we get to allocution, I think that I can explain what's
Do you
going
want
on.
to voir dire him in that regard? Do you want to ask him the questions?
I can, yeah, I'll do that.
Any objection to that?
No. Yeah.
Is that Jamera?
Mr. Khan, you were told that you needed to random drug test, correct?
Yeah.
Did you understand how to do that?
No, not really, because I thought they were gonna call me when I had to go drug test, and I never got a call or anything about that, and all of a sudden I got a call saying that.
So-
I messed up.
So if somebody had explained it to you, you didn't understand.
Yeah,
Is that, do you know more?
no one really explained what I had to do, they just gave me the paperwork and they just did something on my way, no one really explained much of anything, what I had to do in order related to drug testing. So I would have came the next day about it, knowing I had drug testing.
Sir, do you have any problems in general recalling things, understanding things?
Sometimes, well, I'm afflicted with schizophrenia and bipolar disorder. So sometimes I get things mixed up.
Does hold on 1 second. Does the court believe that satisfies, or? I mean, I respect that.
Ms. Edgemere, can you approach and show this to your client, please?
Yes, Your Honor.
Sir, I'm going to have your attorney show you a document, and what I'm going to do is ask if that's your signature on the bottom of that document.
Yeah, it is my signature.
Okay.
I guess I didn't really read all that.
So you did not read this document?
Yeah, I guess I didn't read the whole thing. I don't. I mean, I know that's my signature, so I must have produced the paper. I guess I just didn't read it entirely.
Okay.
Just don't remember reading it.
All right. Thank you. Ms. Edgemere, do you have any additional questions for your client?
No, Your Honor, I was just gonna state that I don't believe that actually says anywhere on there that he's read it. I think he's just agreeing to it with the implication that he's read it.
Mr. Carnes, do you have any questions for this witness?
No, Your Honor.
Any argument, Ms. O'Mara?
Yes, Your Honor, I would ask that the defendant be given another opportunity. He, and as he mentioned briefly, has some pretty significant mental health issues. He has trouble remembering things. He has trouble in general with these things. And like he mentioned, it was the first time he had been on bond, or he's expressed that it's the first time he's been on bond. And I believe that him not going to testing can be explained through a combination of mental illness, cognitive problems, inexperience with the criminal justice system, and then obviously he was gone for a couple of months. We had been in contact with him a little bit. He expressed that he was scared, that he was gonna, that he was in trouble, and I respect. Obviously, he is in trouble, but I think that this is a circumstance that the court should show. I don't know if the word is mercy, but a little leeway with the defendant. Thank you.
When you say he was gone a couple of months, what do you mean by that? I don't see where he missed any court.
Not that he missed court, that he did not test in July, and then he
Okay.
got a bench warrant. Like that.
Okay. Thank you, Mr. Carnes.
Thank you, Your Honor. I do note the defendant has some criminal history, bordering on significant. So I'm troubled with the explanation here. Also, the defendant was clearly ordered not to use controlled substances, alcohol, or recreational marijuana, and we have the positive tests for marijuana today, and I'm not aware of any medical card. So I would ask the court to revoke bond at this time.
Thank you. For the court, having heard the testimony today, I do find that there's a violation of the defendant's bond. He was, as I stated earlier, he was ordered as a condition of his bond not to consume any alcohol, not to consume any illegal controlled substances, including recreational marijuana. He, by his own admission, signed a community corrections release order from his release at the time of jail on July 1st, 2025. At 14:54, so 2:54 in the PM, it clearly states that you are court ordered to submit to substance abuse testing as a condition of your bond or release from jail. You are to report to community corrections at the above address today. If it is after 4:15 PM, you are to report the morning following your release from jail or arraignment. Fail to report will result in a violation. And then it goes on to explain what the testing hours are. Nowhere on that form does it say to expect a call from community corrections as to when you'll be required to come and test. Now, while I don't have any proof that the defendant was on bond in any of these cases, I do show that he has at least 7 prior convictions in his past, going all the way back to 2008 and up to 2024. Some of those would certainly make the court believe he was on bond, including disturbing the peace and 2 driving offenses. So I do find that the defendant was in violation of his bond. Now the question is, what do we do from here? I've got somebody who was charged with an operating while intoxicated under the influence of a combination of alcoholic liquor and a controlled substance. Not doing any testing since his release from jail back on July 1st, and some almost 2 months after his release, we're just shy a few days of 2 months, he's testing positive for THC. That's after having sat in jail from July 9th until, I'm sorry, from June 9th until July 1st. So any THC should have been out of his system, and especially out of his urine, and now he's testing positive for that. And I'm also aware that the lab report just came in.
Yes, Your Honor. I am going to have to amend this. The alcohol results came back at 0, but the blood results came back with a significant amount of active THC. So that is essentially now the allegation is just driving under the influence of marijuana.
Mr. Carnes, is there sobriety test, field sobriety test?
I don't believe there are, Your Honor. The police encountered the defendant after he collided with a house, and I think he was quite shooken up. He did consent to a blood draw and was transported to Munson Hospital at that point.
So June 6th was a Friday, June 9th was a Monday, so he was lodged immediately, I assume,
Yes, Your Honor.
but no field sobriety test.
No field sobriety tests are contained in the report.
What time of day or night was it?
10:52 p.m.
And he struck a house?
Yes, Your Honor.
Sir, when you were downstairs for your testing today, did you get signed up for testing while you were down there?
What do you mean by signed up? Like,
Did they give-
sign more paperwork for more testing?
Did they give you instructions on how to call in and check numbers to see if you are to
No, I don't
test?
know how to do any of that.
Mr. Carnes, is there anything in your report indicating indications of intoxication? The reason I'm asking is because, Michigan's, we don't no longer have the per se for marijuana, so I'm just trying to see the likelihood of conviction.
Your Honor, the officers do describe the defendant saying a lot of words that did not make sense and was speaking sporadically.
Your Honor, I'd mentioned that that's also my client's demeanor today. And I believe that to be his general demeanor.
Well, I haven't heard him say anything today that doesn't make sense. Ms. Eisenmeyer, has your client remained in contact with your office?
He sporadically, has, I believe, Ms. Fiorganto is actually the lead attorney on this case, but she had been in contact with him, and he had mentioned at that time, I believe, that his mental health had gotten a lot worse, and that he was worried and scared and things along that nature, so.
All right. What I'm going to do, given that we are anticipating an amended complaint in this case to remove the alcoholic liquor and go strictly with a marijuana charge, the fact that the defendant has already sat just shy of a month, I am going to allow him to remain out on his current bond. But there will be no more graces. So I suggest maybe somebody walk him down to community corrections and get him enlisted in their programming and make sure he understands how that works. Because the court is to say that I'm less than impressed today is the understatement of the century. So, but I will allow the defendant to remain out.
I appreciate it, Your Honor.
We will set this for a final pretrial September 18th.
Same bond conditions.
Yes, same bond conditions continue.
All right, let's talk about that. This hearing before Judge Corey J. Wiggins was one of those sessions where patience, clarity, and a little courtroom reality check all came into play. The defendant struggled to explain why he hadn't complied with his bond conditions, particularly the requirement for random testing. His explanation was that he thought someone would call him when it was time to test, a belief that would be reasonable if the paperwork hadn't spelled out otherwise. The problem wasn't so much defiance as it was a mix of misunderstanding, inexperience, and genuine difficulty processing the system's requirements. He even admitted he hadn't read through the documents he signed, which left the court unimpressed but still cautiously receptive to the context of his mental health struggles. Judge Wiggins' handling was consistent with his reputation, firm, direct, but not without empathy. He methodically went through the documents, pointing out exactly where the requirements were laid out and why the "no one explained it to me" defense wasn't going to fly. Still, he gave space for defense counsel to make the argument that the defendant's mental health and lack of familiarity with the process played a role. Importantly, Judge Wiggins didn't jump straight to the hammer. He acknowledged the marijuana positive test, the history of prior convictions, and the defendant's shaky explanations. But he allowed him to stay out on bond with a crystal clear warning: no more chances. The defense attorney did about as well as could be done with what was in front of her. She emphasized her client's mental health, framed the situation as confusion rather than willful neglect, and argued for another opportunity rather than revocation. The prosecution, for its part, was pragmatic. They pointed to the positive test, the prior history, and the lack of follow-through, making a straightforward case that bond should be revoked. Both sides stayed composed, and neither slipped into dramatics, which gave Judge Wiggins space to weigh the facts without distraction. One notable detail was the defendant's demeanor. He wasn't hostile, but he came across as scattered and uncertain, often admitting he didn't really understand what was expected of him. The court asked directly whether he had issues with memory or comprehension, and he responded candidly about his diagnoses. That level of candor helped explain, though not excuse, some of his lapses. Judge Wiggins picked up on that distinction and balanced accountability with practicality. The courtroom atmosphere was steady throughout. No raised voices, no heated clashes. The only tension came from the defendant's halting answers and the judge's visible skepticism, particularly when the defendant claimed he didn't know how the testing system worked, even after signing the paperwork. Judge Wiggins summed it up best when he said that describing himself as less than impressed was the understatement of the century. That line captured both the judge's frustration and his restraint. In the end, the defendant walked out still on bond, but with the clearest possible warning that one more misstep would be the end of the road. The court also hinted at the practical solution. Someone needs to physically walk him through the testing process, ensuring he can't claim confusion again. It was a fair outcome, measured, lawful, and patient, but with zero tolerance for repeat excuses. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.